Hello, my name is Kedge, and today I'm going to be answering the question, what exactly is a position statement for a child arrangements first hearing, which is the first hearing dispute resolution appointment. So I'm going to be explaining exactly what it is and then give an example of how to write one. As for myself, I'm a retired police chief inspector. I'm the director of the McKenzie Friends UK network. I'm not a lawyer. I'd rather die in a ditch than being a lawyer. I'm a non-legal entity. I don't give legal advice. I just give people advice as an informed friend through my almost now a decade of experience in the family courts as a McKenzie friend. If you haven't heard of me before, then please join my Facebook group and also subscribe to my YouTube channel. Now, to start off, I need to explain a mistake that many people make when submitting their applications, their C100s or C1A. For some reason, people feel that on submitting their applications, they then need to send to the court narrative statements full of assertions and allegations. They want to send to the court examples of emails and texts or even recordings. That's exactly what the court does not want you to do at all. And indeed, it's very clear on the C100, it says do not send full statements to the court. If a full statement is needed or any additional documents are needed, the court will ask you for them. In the practice directions 12.19, which is the rules you have to follow when going through a family arrangements application or family court application, it states this. This rule applies to proceedings for a Section 8 order, which is a child arrangements order. Unless the court directs otherwise, and it says this in capital letters and in bold, a party must not file or serve any document other than in accordance with these rules or any practice directions. So must not serve or file any other document. In completing a form prescribed by these rules or any practice directions, for example the C100, you must not give information or make a statement which is not required or authorised by that form, or to file or serve at a hearing any witness statements of the substance of the oral evidence which a party intends to adduce, or any copy of any document which a party intends to rely on. So you are not allowed to submit any evidence to the court or to the other side unless you have the court's permission. So please don't send any other documents to the court. However, there is an exception to that. By common convention, usually 2 days before a court hearing, or indeed on the day if you're attending in person, both parties are allowed to submit what's known as a position statement. Now, a position statement doesn't contain any appendices, doesn't contain any evidence, you shouldn't have any other documents attached. A position statement should be no more than 2 sides of A4 paper, where it sets out in very plain terms why you're at court and what you want during that first court hearing. What are you looking for? What are you looking for the court to determine? And also maybe a longer term view of what you're looking for in terms of child arrangements. So it is, in essence, what your position is for that hearing. It's not about making allegations or submitting evidence in relation to the other party or in relation to the case. And it's really critical to understand that, which is why this video is about showing you an example of what a good position statement is and how we write one and how it's different from a narrative statement. So that's really important to understand from the start. Now, the other thing which is important is when you write a position statement and file it with the court and give it to the other side may indeed give you their position statement. what the court absolutely doesn't want you to do is to then look at their position statement and say, no, I disagree with that, that's not right, that's a lie, that's just mudslinging, and then write another statement in response to theirs. And then the other side read yours and starts doing the same thing. And all of a sudden you're exchanging even more statements. And then you disagree with those statements, and then you exchange more. And all of a sudden things become totally unmanageable. And the chances are the court will just throw everything out that you've submitted. So please don't do that. The courts do not want you to do that. You don't need to do that. If there are any safeguarding issues, then the courts will deal with those separately. So that is what a position statement is. It's just a concise summary of why you've made an application and what your views are in relation to the first hearing. So let's explore that then for the rest of the video. Now, in order for this video to make sense, I need you to download the PDF, which is a mock example of a position statement for the first child arrangements hearing. Now then, how do you get hold of this? So, if you're on my website, just look down below and you'll see the link to this PDF. If you're on Twitter, LinkedIn, Facebook or YouTube, just please go to the text and you'll see that I've put a link to the PDF in any of the text that I've used along with this video URL. So what I'm going to do is just pause for a couple of minutes to allow you to just go away and do that. So please press pause, print this out and then come back, and in the meantime I'm going to go and get a cup of coffee. Looking forward to catching up with you once you've printed the position statement out. So welcome back, and I've got my coffee here. Cheers. This is based on a completely fictional scenario with fictional locations and characters. And indeed, these are the characters that I use for my McKenzie friend training courses, which are also excellent if you're a litigant person and want to find out more about the family court system. So have a look at the website below if you're interested in further training. Let me just give you a little bit of background before talking directly about this position statement. And the background is this. We have Mr. Matthew Groves, who's married to Mrs. Abigail Groves, and they have two children of the marriage, who's Daniel, who's 12, and Sandy, who's 4. Daniel is at secondary school and Sandy is at nursery, but is heading towards primary school. Dad wants Sandy to go to primary school, but Mum wants to home tutor Sandy, and that's been a disagreements between them for a long time. About 6 weeks ago, the marriage came to an end. It's been declined for a number of years, but it got to the point that it's now no possibility of a reconciliation, lots of arguments for a number of years. And Matthew Groves 6 weeks ago moved out and moved into a bedsit. Unfortunately, since moving out 6 weeks ago, Abigail hasn't allowed him any contact with the children, and indeed isn't communicating with him at all. And so Matthew Groves feels that he has to apply to the court for a C100 so that he can gain contact again or access with his children. He's also very concerned because Abigail is a French national. She has no ties to the UK. She has the passports of both Daniel and Sandy, and having had no contact from her for 6 weeks, he's worried that she might be thinking about going to take the children and just disappearing to France. Now, in reality, this is very unlikely. There's no evidence to support that. It's just a concern. But he feels that a prohibited steps order may be useful at this point, just to reassure him that she's not going to take the children abroad without his consent. So we've got a child arrangements order for him to have contact with his children. We've got a specific issues order to look at in relation to whether Sandy should go to a primary school or be homeschooled by mum. And we've also got a potential prohibited steps order to prevent mum from taking the children and just moving back to France. So that's the basis. So let's take a look at the actual statement then and go through that point by point. So this is the position statement of Matthew Groves, who's the applicant. He put in his C100. Cafcass had done their safeguarding phone call and letter, and now it's just a couple of days before the first hearing where Mr. Groves is submitting his position statement and providing a copy to the court and the other side. Now, a good position statement at this point should be no more than 2 sides of A4 paper, because the judge has to have time to read it. He or she has probably got about 2 minutes before the court hearing starts to have a quick read, and also the other party needs to be able to have the time to read it and understand it. So the shorter it is and the more concise it is, the better. So no more than 2 sides of A4 paper. And when I do a position statement for clients, I always split it up into these sections. The first section is what's known as the overview. The second section, proposed interim contact. Thirdly, what my client's view is on the longer term contact, maybe looking towards a final order, what they project into the future. Any specific issues and any prohibited steps orders. Because it's not a statement that contains any evidence, it doesn't actually have to be signed as a statement of truth. So you don't need to necessarily add that paragraph in the end to say this statement is, to the best of my knowledge and belief, true, because it contains no evidence. So let's look at page 1 of the statement, which is in the standard format in front of you. It's in the Sandford Family Court, case number on the top right hand corner, and it's a matter of Daniel Groves and Sandy Groves, who are the children. Daniel is 12 and Sandy is 4. Mr. Matthew Groves is the applicant, and Mrs. Abigail Groves being the respondent, and this is the position statement of the applicant. So the first section then is the overview. Here at 1.1, Mr. Groves says, I've applied to the court for a child arrangements order, including a specific issues order regarding schooling for Sandy and a prohibited steps order to prevent the children being taken out of the UK pending proceedings. Love that first sentence or first paragraph. Just explains exactly why this application has been made and why this matter is in court. Everyone can read that and understand that very quickly. 1.2. Respondent and I have been married for 12 years. Good information. 6 weeks ago, I left the marital home as the marriage has broken down with no prospect of reconciliation. Now, for the last 2 years of the marriage, there has been many arguments on both sides, and he says, I acknowledge the concerns raised in the Cafcass safeguarding letter in relation to the acrimony between both of us. Again, I really like this approach, because this is Mr. Groves saying, look, over the last couple of years the marriage did deteriorate, and actually it probably wasn't that pretty. I mean, how often during the end of a marriage do people actually just, hug and kiss and then go off down the yellow brick road happily in different directions? It doesn't happen very often at all. There's a lot of acrimony. And sometimes putting your hand up to that just shows that sense of self-awareness, and the impact that that has on the children is vitally important. And he's done that here. He's actually said that he recognises that that relationship hasn't been good. And he actually goes further to say that the The home environment has at times been toxic and not in the best interest of the children, but he wants to do now is to build positive co-parenting relationships. So let's draw a line on the past and let's just move forward positively for the sake of the children. So yes, really like that approach. 1.3 says, since moving out, I've had no access to the children, including no indirect contact. And there's been a lack of productive correspondence between myself and the respondent. So he's outlining there a communications problem. Mediation was attempted, but the respondent declined to take part. So just good open information there. No mudslinging in there, just saying how it is and the problem. 1.4. I accept that due to my work commitments as a senior health and safety manager, that the children will reside with the respondent. In my application is to determine the time spent with myself, and I think that's a really good, honest approach. Once again, Mr. Groves is saying that, look, this application isn't about the children living with me, it's about the time that they should spend with me. And hopefully that will calm a few nerves and be an olive branch again to Mrs. Groves to start that positive co-parenting, and certainly to hopefully start that initial contact. 1.5. The respondent is a French national with no ties to the UK. Her family live in Béziers, France. Although I have no direct evidence that she's planning to return to France with the children, it would be reassuring to have a prohibited steps order in place pending proceedings to prevent the respondent leaving the jurisdiction of the UK. So really, that's just a bit of a call for help here. He has some concerns, no evidence to suggest that Abigail Groves is going to go to France, so this isn't an urgent application. But he just wants to be reassured that that isn't the case. And I'm sure that sort of thing could be resolved at the first hearing in relation to Mrs. Groves just giving an undertaking that she won't leave the country, and that'll probably be all that is needed. 1.6. Over the last year, there's been a dispute over the future schooling for Sandy. I wish for Sandy to attend the St Edmund's Church of England Primary School in Sandford, whilst the respondent would like Sandy to be homeschooled by her. There are no issues in relation to Daniel, who has always attended mainstream schools and is settled in the Sandford secondary schools. Now, it's not unusual when applications are made that there's disagreements in relation to children's schooling. We actually deal with them more frequently than you think, and if they can't agree or compromise, then of course it's a matter for the courts to actually decide. So what we have here in terms of a first page and an overview is, in my view, excellent. You can read that in 2 minutes and understand exactly what's going on, and that's the position that we need our client to be in when this is submitted. So that's a great start. Okay, so let's move on to the second page. So page 2 now, in the second section, it says proposed interim contact. Now, there isn't such a thing as a position statement that fits every circumstance. So it could be that there are times where more needs to be written there in terms of what a person may consider to be reasonable interim contact. So you have to play this by ear a little bit, but if in doubt, then please contact the McKenzie Friends UK network and we can certainly help you with the statement. But as far as Matthew Groves is concerned, he's kept it relatively short. So let's have a look at what he says at 2.1. He says, I'd like contact with our children. Now, he says our children. Fantastic. So he says, I would like contact with our children as a matter of urgency. He doesn't say my children. The reason why we don't say my children is that children are not a possession. You don't own them. So you have had children with your ex-partner or wife, and so that they are our children, being inclusive of the other person's parenting and therefore reducing the acrimony, tension and conflict. Of course, he would like to see them as a matter of urgency. He hasn't seen them for 6 weeks. From the time of the application, indeed, it might be a number of weeks. more before we actually get into a court for the first hearing, usually 6 weeks for the first court date. And hopefully then some initial contact can be negotiated. He says, I'm currently residing in a one-bedroom bedsit, which is perhaps not appropriate for overnight contact at this time. And again, that's really good, because what Matthew Grove's doing is applying his own safeguarding considerations for the children. So that's a really strong message to the courts, that this person, it's not just about him and wanting to see the kids and wanting the kids to stay over, no matter what. He's actually applying some consideration as to their best interests and needs, and he's saying this one-bedroom bedsit isn't suitable. But he is currently looking to move to more appropriate rented accommodation in the very near future, so that could be taken into account if there's going to be interim contact, that maybe in a few weeks he will be in more suitable accommodation. He says here, and I like this, I'd welcome the views of CAFCAS and the court as to the suitable interim contact during the weekends, and would be willing to attend mediation with the respondents. So what he's doing there, he's not saying, I want, I demand, I must have, these are my kids. That's a horrible, horrible approach. What he's basically doing here is saying, this is my situation, I know it's not ideal, I believe it's going to improve very soon, but I would welcome the views of CAFCAS and the courts on this matter. I'm interested in hearing what CAFCAS and the courts thinks might be reasonable given these circumstances. The courts are going to really like that, because this is a person who's showing that they're prepared to ask the question and to listen rather than to demand what they want. Because this is all about the best interests of the child and not what a parent wants. So it shows that he understands the system, and straight away he's being child-centred. So that's going to put himself in a really strong position, and that's totally the correct way in which to approach a first hearing. So quick pause then, and then we're going to move on to the third section, which is proposed longer term contact. So now we're coming to the part of the position statement, which is section 3, which is the proposed longer term contact ideas. And what we're trying to do here is actually to project 3 to 6 months down the line, if there was a final hearing or if this court proceedings were over, what sort of contact Matthew Groves has in mind. And don't forget, he's already conceded, he's already stated that he's not seeking residence. Now, this first bit I really like, because it says this proposal is intentionally open in its approach to facilitate discussions, because what I personally don't like is when you get your first position statement, you receive it from the other side and it's just really specific, like it's almost locked down so you can't move and you can't breathe. And it says from Friday after school at 3 o'clock, the children are picked up and they go to dad's and they stay at dad's until 5 p.m. And then there's an exchange midweek at certain times, and handovers have specifically got to be at this location. And it's really detailed almost to the minute. I don't like that. And it's not required at this stage at all. That might be something you present at a final hearing. What we need to portray at this point is to be open to negotiation, to be open to listening, because that will inevitably give you a much better outcome. The way you do that is not to be too specific, so you just give a vague idea as to what you may be looking for without being intentionally specific, and saying that you're happy and open to return to mediation and to be able to discuss these headings in greater detail and more specifically. So you're showing yourself to be open to negotiations. There are certain set headings which you should be thinking about when it comes to child arrangements, particularly if children are at school. So he starts off with term time. every fortnight, so every other weekend with overnight stays from Friday until Sunday, without at this point being too specific in relation to timings. Just saying here, half-term holidays. There's 3 one-week half-term holidays throughout the year to be shared equally. No need at this stage to actually define what that looks like, who has them when, how they should be split. Easter holidays is 2 weeks, again, very general, to be shared equally, with Easter Sunday to be alternated each year. And for Christmas holidays to be shared equally, that's a 2-week holiday, with Christmas Day alternated every year, which is not an unusual order. Again, the details of this can maybe be determined outside of court, return to mediation, or as we actually continue through the process of the next hearing. Children's birthdays, very open proposal for the parent not having residence on those days to have contact with both children together. Certainly doesn't seem unreasonable from my perspective. Parents' birthdays, again, for the children to spend time with the parent on their birthday, and traditionally Mother's Day and Father's Day for the children to spend time with that parent. Handovers, drop-offs and pick-ups to be shared equally, so the driving should be shared. The general thought between that is that it is important for both parents to share or take part in handovers, pickups and drop-off, because it shows to the children that the parents are communicating, and both parents are showing to the children that them going to see the other parent is important. And it's a really key message to say, well, I'm now taking you to mum's, I'm now taking you to dad's, that they know that as parents they feel loved and supported, and that they know that their routine is supported by both parents. Really important for their welfare. And of course, direct or indirect contact. So indirect contact by telephone, letter, Skype, FaceTime, or any other multimedia or social media platforms. Not asking for that every single day, might be once a week. Certainly if you're away on holiday for a couple of weeks, or the children are with a parent for a whole week during a half term, then you may want to build in some telephone or Skype contact for that. So that's a really nice open proposal which just lays the foundations on which to actually build and hold discussions, and I think that's a really great way to approach it. And of course the statement then ends with a reminder that there's also specific issues for the court to determine how Sandy should be schooled, whether it's the mum doing homeschooling or Sandy goes to the Church of England primary school, and then a prohibited steps order just to prevent mum from leaving the country with the kids without permission and not coming back. Highly unlikely anyway, but it is for reassurance. And then any point on that is that I would suggest that rather than prohibited steps order, what would be appropriate to resolve that is if Abigail just gave an undertaking to the court, which is just a promise that she wouldn't actually take the children out without permission, and that would probably resolve that without that being taken any further. So let's have a quick summary of the position statement. So this, in my mind, is a really positive, sensible position statement. It doesn't declare war on the other side, it doesn't sling mud, it accepts that things in the past may not have gone well. It's very child-centre focused. It makes Matthew Groves appear entirely reasonable, and that he has the interests of the children at heart. He's not suggesting that Abigail doesn't. And he wants to actually possibly co-parent, and he's very much open to negotiation and getting these things actually sorted out through discussions. Now, people may ask me at this point, well, hold on a minute, what was if Abigail is making allegations or assertions against him, safeguarding issues? Well, even though you may have actually read something like that in the safeguarding letter that Abigail's making allegations, this is not the time to respond to allegations because it's not an evidential statement. And the second you start responding to allegations, then in fact it just fuels that fire. Allegations can be dealt with by the court through their safeguarding measures. They will be resolved. You don't need to start defending yourself in this position statement, and you certainly must never at this point then be throwing allegations back. Well, she's made allegations against me, so I'm now going to use this opportunity to make allegations against her. Where's that going to leave you as a parent who wants to move forward positively, building co-parenting relations for the best interests of your child or children? The focus has now suddenly turned on the two of you going to war. You really need to rise above that and not make that mistake, which so many people make. This is a first position statement. It's not an opportunity to start throwing allegations at each other. If you like help at all in writing a position statement or indeed any aspect of the family court process, then please get in contact with us at the McKenzie Friends UK network, and I can put you in contact with a number of McKenzie Friends who are members of the site. They're all independent McKenzie Friends, but you can have a 1 hour free chat with any of them, and I'll happily put you in contact. And you can do that by going to the website www.lightnothate.co.uk, and that web address should be appearing on the screen just below me. So looking forward to you contacting us and for us to be able to help you. I hope that's been useful.